Hello, welcome. This is Professor Nathenson. Welcome to the Q&A session. I'm going to be on here starting at 2 o'clock today, Saturday, and I'll take any questions that you have. Doesn't look like we have anybody here yet, so I'm just going to sit here quietly and see what we got. Okay. Right now it's showing no viewers, but if anybody's there, do me a favor and let me know if the audio quality is coming through. Okay, I greatly appreciate that. Thank you. What you can do to let me know if the audio is working is click on Q&A, and instead of sending me a question, just say, hear you just fine. That would be great. Welcome. Welcome. Are you able to hear me okay? If you are, could you please do me a favor and click on Q&A and just send me a question, but really just a comment saying that the audio is working just fine. I'm live, but right now we're just in the making sure everything works portion of the show. Okay. Well, again, welcome. This is Professor Nathenson. Let me know if you have any questions, anything you'd like to discuss, any questions you have on civil procedure regarding the bar exam. Also, if you can, click on Q&A to give me any questions you have, and additionally, let me know if the volume is coming through okay. Hey, welcome. Welcome to the Q&A session. We just started. Let me know if you have any questions. Also, even if you don't yet have any questions, what you can do is click on the Q&A button. That's how you pose a question or pose a comment. And additionally, if you could do me a favor, let me know if the audio is coming through okay. Thank you. Meanwhile, I'm just going to enjoy a little bit of coffee. Hello there, it's Professor Nathenson. We're just getting started here. I think we'll wait a few minutes until more people are here. In the meantime, I hope everybody's preparation for the bar exam is going well. I guess until we get some questions and some more viewers, I'll tell you a little bit about my bar exam experience. I remember taking the bar. I studied for it in 1998. Back then, the books, I used the Barbary books, and they were humongous books. You know how a normal book is about that big, like a normal case book? Well, the Barbary books were much taller, which made them hard to read and hard to carry around because they were really long. They're like 11 by 14 books. And when I was studying for the bar, it was a terrible storm, and all of the lights were out in my house for 2 weeks, believe it or not. So many trees blew down in my town that electricity was out in many places for weeks. So I was literally studying for the bar exam, Abraham Lincoln style, which meant I was studying using flashlights and battery-powered lamps and candles, if you can believe it or not. So I guess you guys have the modern technology of electricity, and hopefully your studies go better. Okay, well, now we have a bunch of people. Welcome. It's Saturday. I hope everybody's eating well. I hope everybody's resting well. I hope the studies are going well. The way the Q&A works is you click on the Q&A button. Okay, what you do is there is a little grid in the upper right-hand corner. It looks like a bunch of boxes. Okay, you look there, upper right corner where I'm pointing. You click on that and you click on Q&A, and then you can post any questions that you might have. Okay, for instance, I'm going to post one right now. Just saying, hello. And the way the Q&A works is everybody is able to see the questions you post. And you can upvote and you can downvote any questions you have. Actually, you just upvote them, right? So if you see a question one of your friends has asked, and you think, yeah, I'd like to have Professor Nathenson address this as well, then click on the +1 button. Yeah, it's a +1. And that way other people will be letting me know that more than one person wants to have that question asked. Now, in addition to questions, I greatly appreciate it if you could let me know two things. First, is the volume coming through okay? Can you guys hear me okay? Is the volume too low? Is it so high that it's distorted? I think I haven't set it at a good level, but you can let me know. So again, click on the grid icon. It's a bunch of boxes. It's up there. Click on that, and down will pop down a couple icons, including one for Q&A. Click on Q&A, click on Ask a Question, and let me know who's here. Say hi. Let me know that you can hear me okay. And of course, if you have any questions, ask the question. Well, while I'm waiting for that, I'm going to check the email, see if any of you have written me there. Okay, good. Hello, Kamar. Good to hear from you. Thanks for confirming that the volume is working out. Thank you very much. So, a couple things to talk about. First, online at my website, I have a lot of materials. You should know about all those materials. But if not, let me pull up my website real quick. Tell you where to go to get stuff. Okay, so give me a second. I'm going to pull up screen share. There we go. All right. This is one of the cool things about Google Hangouts. Not only can you guys all hang out with me, but I can share my screen with you as you want. All right, so now I'm going to click over to that myself. There's a huge number of MBE related resources. Just tap on teaching, civil procedure, and then tap on, there we go. Tap on Civ Pro Bar Exam resources. Okay, I have YouTube playlists. I have MBE resources. So for instance, go to YouTube or go to the nathenson.org/courses/civpro/MBE-resources. I have a huge amount of stuff here. Some of the stuff is developed for my JD students. Some of the stuff was developed for the MBE. Obviously, the stuff for MBE and JD are both things that you may be able to use. So for instance, under personal jurisdiction, you can see a large listing of materials such as problem set, flow charts, various tables and handouts regarding personal jurisdiction, and additionally videos, some of the dedicated personal jurisdiction videos. Okay, so that's one place you can go. Now, going back to the main part of Nathenson.org, again, if you click on Teaching Civ Pro Resources and click on YouTube MBE Playlists, then that's going to take me over here, and it's a bunch of playlists related to MBE. So, for example, the review I gave just last week, you can find here at that link the videos related to the February 2016 MBE. And I have videos from past 2 bar exams there as well. And sometimes I cover different things. Sometimes we spend more time on a topic, less time on a topic. Generally speaking, in the last set of reviews, Dean Singer asked us to limit ourselves to about 3 hours. But for instance, in the February 2015 MBE, I actually took 2 days of between 3 to 4 hours or more. So that's humongous long review. All right. And then there's resources listed by topic as well. Another place you can go that has lots of stuff is you click on the YouTube link on my site, and that's going to take you directly to my YouTube page, and you'll see for returning subscribers or for new visitors, I have links to MBE review videos. The place you really want to be is to review the playlist on MBE. I have click on all the playlists and look for the playlist that is this one with 34 videos. Huge number of videos selected for those studying for the bar exam. You can see I have reviews from February 2016 and the past 2 bar exams. Some of them are specific to a topic, like subject matter jurisdiction, due process, pleadings, venue, joinder, motion, supplemental jurisdiction, blah, 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 discovery, joinder, Erie doctrine, all of that. So one of the benefits of having the website is even if I'm not able to get to a topic in a 3-hour review, which obviously you can't talk about everything and certainly not in great detail, I'm nonetheless able to make those materials available to you online. All right, now I'm going to go back to the main page here. Again, we have a few people here. Now, to be clear, this session is a Q&A session. So I'm not going to just lecture on topics. It's a Q&A. This is your opportunity to ask any questions you have. So hopefully you have some questions or things you'd like to be clarified, like matters of personal jurisdiction or subject matter jurisdiction or pleadings or Erie or what have you. So what you should do if you have any questions is click on the button. There's a grid icon. It's like 9 little white boxes. Click on that and you get a pop-down menu. And that will allow you to click on Q&A and then ask your question. And any questions you have, they'll show up to me, they'll show up to anybody else, and then I can address your questions. Okay. Okay. Hi, Marianne. Marianne's question regards supplemental jurisdiction. The question is, and you can see it by clicking on Q&A. Give me a second. Let me confirm that you're able to see it as well. There we go. All right. See, when you click on Q&A, you're able to see your colleagues' questions. So Marianne asks a really good question, an often misunderstood aspect of supplemental jurisdiction. Okay, now what I'm going to do, and you can do this at home, is go to the handouts I have on the website, and I'm going to use the handout to talk about it, and then I might give you an example or two, okay? And while I'm pulling up those materials, anybody else who has questions, because the room's starting to load up a little bit now, don't be shy. There's a icon up there, looks like a grid of my little boxes. To see your colleagues' questions or to ask a question yourself, we've already had a couple, is click on that button, the grid icon. Popping down will be a Q&A icon. Click on that, and then you can ask any questions you have. Okay. Now, Mary Ann's question is about supplemental jurisdiction. So here's what we're going to do. We're going to do what we did before. I'm going to go to screen sharing. There we go. Alrighty. Nathenson.org. Teaching, civil procedure, right here, bar exam resources rather, MBE resources, and then supplemental or subject matter jurisdiction. Alrighty. All right. I'm going to pull up this handout, which is supplemental jurisdiction analysis. And as you can see, I have a whole bunch of other handouts on supplemental jurisdiction, as well as a all those right there. Alrighty. The 1367 has 4 parts. Mary Ann's question focuses on the second part, 1367B. But I think it's nonetheless worth very briefly talking about the function served by the 4 parts of 1367. Okay, 1367A is a grant of supplemental jurisdiction. It says, which I'm sure you already understand, that if you have original jurisdiction, such as diversity jurisdiction, federal question jurisdiction, then 1367A grants supplemental jurisdiction over all claims or the joint or additional parties when those claims or parties involve the same common nucleus of operative facts as the claims for which there are original jurisdiction. Okay, so you need diversity, you need federal question, or some other original jurisdiction statute, the ones that give direct jurisdiction to the district courts. All right. So, for instance, if you have, and let me pull up a page here that I can draw with, make sure that you're able to actually see that. I think I'm going to have to change the share. Give me a second. Just stop sharing. And we're going to share a different page. There we go. OneNote. Alrighty. You should be able to see this now. Say we have a case like United Mine Workers versus Gibbs. Okay, plaintiff versus defendant. Neither one of them are from different states. They're both from, say, Tennessee, like in the Gibbs case. And you have a federal question here. Okay, so here's an example based on Gibbs. Say it's for federal employment discrimination. All right. Well, that's going to be a 1331 federal question. There's going to be original jurisdiction because 1331 is that original jurisdiction in federal courts. But what if the additional claim is joined under Rule 18A for, say, state employment discrimination? Okay. Well, remember, I said both P and D are citizens of the same state. That means there's going to be no diversity jurisdiction. So we need to ask, is there going to be subject matter for this state claim? Well, there can't be 1331 because the claim is not a federal question. Can't be 1332 because the claim lacks diversity. What about 1367 supplemental jurisdiction? Well, first we ask under 1367A. All right. do the claims arise from common nucleus of operative facts? That means the facts that are central, okay, to both the federal question claim here and the state claim are the facts that are operative, in other words, relevant to the state claim, also operative and central towards the federal question claim. And here, I think that if P assume B for employment discrimination based on the same set of facts, okay, then you're going to have a common nucleus of operative facts, regardless of whether the claims are based on federal law or state law. In other words, you just have two different theories trying to obtain similar or identical relief. All right, so 1367A is going to grant supplemental jurisdiction. Now, what I'm doing with Marianne's question is answering it in a very roundabout way. What she's asking about is not A, but 1367B. All right, so give me a second here. All right, let me go to this handout that I used with my students just the other day. It makes it easier to flip back and forth. All right, here we go. Well, A grants jurisdiction, right? There was original jurisdiction. It was the same constitutional case using the Gibbs standard. And because the answer is yes, A provides statutory grant of SJ. Does B take away? And that's the function of 1367B. What it does is in cases where 1367A grants jurisdiction, in some diversity-only scenarios, 1367B takes it away, right? Here is the main thing to remember about 1367B. And it takes away supplemental jurisdiction in a number of drawn scenarios, and I actually really say not involving supplemental plaintiffs, but rather involving plaintiffs, okay? What you do under 1367B is you ask this series of questions, and again, you can find this on my website, all right? B does not create supplemental jurisdiction, it just takes it away in certain scenarios. And to do the analysis, you have to ask the questions that come below. First, what's the basis for original jurisdiction? Okay, is the original jurisdiction based solely on 1332? If it is, then you have to move on to the next question. But what if original jurisdiction is based on some other basis, such as 1331? Well, if that's the case, then you don't have to move on. So going back to our hypo from just a moment ago, the basis for original jurisdiction was 1331, right? It wasn't diversity 1332. Therefore, B, 1367B, cannot divest jurisdiction, okay? And 1367B analysis is over. Well, let me give you a scenario where 1367B might divest jurisdiction. Let me get a pen here. There we go. Say you have plaintiff, citizen of Florida, versus defendant, citizen of California, okay, versus a third-party defendant, citizen of Texas, all right? The plaintiff is seeking $100,000 for a car crash, all right? And then the California defendant, acting as a third-party plaintiff, is seeking a contribution of up to $100,000 from another driver. Say it's a three-car wreck, all right? So here you have a third-party defendant, all right? Well, we can see here that we have original jurisdiction of Florida versus California, right? If that controversy is good, the parties are completely diverse. Equally so, we have original jurisdiction over the third-party claim, California versus Texas, seeking $100,000 in contribution. All right, so you have original jurisdiction over the original claim and over a third-party claim. Now, as a reminder, the rules permit Florida, the plaintiff, to assert a claim under Rule 14 against the third-party defendant, Texas. That's Rule 14, all right? And under Rule 14, let's get the original plaintiff, Florida, can assert a claim against the third-party defendant under 14 if and only if the claim running this way arises from the same transaction or occurrence as this claim. All right. Now remember what I said. It's a three-party accident. All right. So then the joinder rules permit the claim to be asserted. But joinder is not the same thing as supplemental jurisdiction. Okay, for a claim or a party to be properly joined, it's got to satisfy both the joinder rules as well as the jurisdictional rules. So Rule 14 is satisfied, but what about jurisdiction? Well, let's say the plaintiff here is only seeking $5,000. Okay. Say, for example, the plaintiff is seeking $100,000 in personal injury against one driver, but is suing the third driver, Texas, for only $5,000 worth of vehicular damages, okay, arising from the same accident. Well, we immediately see that there's a problem here with jurisdiction for Florida versus Texas, all right? We do have 1332 jurisdiction over the original claim. We have 1332 diversity over the third-party claim. However, 1332 jurisdiction is lacking here because the amount of controversy is too low, right? It needs to be at least it has to be over $75,000. What about supplemental jurisdiction? And this is the question Marianne is asking. Well, 1367A is going to grant supplemental jurisdiction. All right, it's going to grant supplemental jurisdiction. But 1367B can take it away. Well, the first thing we have to ask is, what's the basis for original jurisdiction? Is it based solely on 1332? The answer here is, of course, yes. The only basis for original jurisdiction is 1332. This is a negligence claim arising under state law involving three vehicle drivers. All right. Well, this question is answered in the affirmative, 1332 only. All right. Then we need to move on. Then we have to ask whether applying supplemental jurisdiction over that claim, that supplemental claim, would be inconsistent with 1332. And the answer is, it would. It would. The amount of controversy is way too low. All right. We move on. Then we have to ask whether exercising supplemental jurisdiction, bring that out, there we go, whether the supplemental claim falls under any of the joinder scenarios in 1367B, okay? In other words, if the original basis for jurisdiction is only 1332 diversity, and the supplemental claim would itself flunk 1332, then we have to ask whether or not the joinder scenario for this claim, right, this one right here, whether or not it falls under the joinder scenarios, one of them right here. These three scenarios are contained in section 1367B. Now, this is why supplemental jurisdiction is so very testable. To understand supplemental jurisdiction, you need to understand all the flavors of SMJ, subject matter jurisdiction. You've got to understand federal question and diversity and other original jurisdictions like patent or interpleader. You also have to understand removal jurisdiction. And additionally, you have to understand the supplemental jurisdiction statute. And when you get to 1367B, additionally, you have to know what kind of joinder scenario you have here, which means you got to understand all the joinder rules. All right. Well, let's look at what we have here. It's Florida versus Texas, right? It's a plaintiff suing a third-party defendant. Does that fall under any of the scenarios here in the statute? Is this a claim by a person seeking to intervene as a plaintiff under Rule 24? The answer is no. It's not. Plaintiff's not an intervener. The claim is by the original plaintiff. Is it a claim by a person proposed to be joined as a plaintiff under Rule 19? Recall that Rule 19 is required joinder. This is not a claim by somebody proposed to be added as a plaintiff and then assert a claim under Rule 19. This is a claim by the original plaintiff. All right. Is this a claim by a plaintiff? Oh, starting to look good, right? Claim by a plaintiff. Yeah. It's a claim by a plaintiff, all right. There it is, right? Florida. Is it a claim by a plaintiff against a person made parties under Rules 14, 19, 20, or 24? And the answer here is, yeah, it's a claim by a plaintiff. And it's a claim by a plaintiff against somebody joined under Rule 14, Rule 14, third-party practice, right? Here's the original P. And here's the Rule 14 third-party defendant. What does that tell us? That means that this third-party claim not only lacks original jurisdiction under 1332, lacks supplemental jurisdiction. But the problem with supplemental jurisdiction is not 1367A, all right? 1367A would grant jurisdiction because in this three-car wreck, all these claims share a common nucleus of operative fact. A lot of the same evidence is going to be relevant or dispositive to all three claims, right? The original claim, third-party claim, and even Florida versus Texas's claim. The problem is not A, which would grant supplemental jurisdiction. The problem is 1367B, which divests that jurisdiction. As a result, no original jurisdiction and no supplemental jurisdiction. Now, keep in mind that under 1367, you may have to go on to analyze C and D, right? C says that if A is satisfied and grants jurisdiction, and B does not divest jurisdiction, that even then the court may have, or the court oftentimes has the discretion to punt. In other words, decline to exercise supplemental jurisdiction. And what D does, it's a savings clause that gives a short grace period for refiling of the claim in state court without statute of limitations problems, assuming that the original federal lawsuit was timely filed. Okay, now I'm going to go back to the main screen, stop screen sharing, go back to this. Marianne, please let me know if that was helpful to you. I'm going to click done. That was answered. And, just why don't you send a little Q&A back and let me know if that was helpful or if you have any follow-up questions. Now, for anyone else that's here, if you want to ask a question, just click in the upper right. There's a grid icon. You can click on that. That will bring up a Q&A button. Click on Q&A. That way you can pose any questions that you might have. Marianne, you are very welcome. I'm glad that was helpful to you. Okay. Well, I'm sure you guys must have some questions. In the meantime, I'll talk briefly about what is going to be on the bar exam in terms of the MBE. So I'll take this opportunity to talk for a few minutes, and then you can add any questions that you might have. Give me a second to pull up the screen. There we go. Good. All right, whoops, wrong screen, my bad. Okay, I'll answer both questions in a minute, but I'll still take the opportunity to comment on the bar exam itself. Where we are, here we go. All right. And then I see a couple questions from Jeremy and Kamal, which I'll be very happy to take in a second. The big thing with the bar exam, for those of you taking Florida, perhaps some of you are taking other states, but for Florida, my focus here is on the MBE. And regarding civil procedure, the MBE will have 27 questions on federal civil procedure. Okay, now a couple important things to know. First, that's only going to cover amendments to the FRCP through 2012. Okay. In other words, that means any change to the FRCP since then, you're not going to be tested on. Okay. For instance, there were some major changes to the FRCP in December of last year. You're not going to be tested on those. The second thing that's really important to note is that the bulk of the questions you're going to be asked are based on part 1, part 3, and part 5 of the MBE outline. Now, you should have this handout. I'm sure Dean Singer gave it to you. If for some reason you don't have it, go to the MBE Resource Center on my website at nathenson.org. Just click on nathenson.org, and then on a civil procedure, then look for the MBE Civil Procedure Center, and you'll find a link that'll eventually take you over to this. It'll be in the overview of the MBE. What that means is topics like SMJ, personal jurisdiction, venue, Rule 11, pleadings, joinder, pretrial, discovery, motions, like a Rule 12 motion, a Rule 56 motion, directed verdicts, judged as a matter of law. That's going to be 2/3 of the question. That means 18 out of 27 questions are going to come from there. The other 9 questions will come from parts 2, 4, 6, and 7. And things like appealability, juries, preclusion, the right to jury trial, and Erie, right? Law applied by federal courts. Okay, now let me get back to the main screen and answer some of the questions that have been posed in the meantime. All right, I'll take Jeremy's question because it ties into the 1367 that we're talking about a few moments ago. Right, Jeremy asks, can you run a scenario where 1367B will not prevent a plaintiff from suing a defendant? Okay, I'm gonna recast your question somewhat, Jeremy. Think about scenarios where 1367B does not divest jurisdiction. Right. Now here, I think it's important to actually look at the statute for a second. So give me a second to pull up my OneNote. There we go. All right. Here's the statute itself. Okay, let me clean it up a little bit. Had some markups there from my OneNote last Wednesday. There we go. All right. Now, A is G, the grant of jurisdiction. T is the divestment or the taking away of jurisdiction. And B only kicks in, as we were saying a few moments ago, when original jurisdiction is premised solely on diversity jurisdiction. Okay. So here's one quick way of answering Jeremy's question. If you're looking for some quick things in your checklist about supplemental jurisdiction, let's assume we have a scenario where 1367A would grant jurisdiction, right? All the claims that you have original jurisdiction, say it's diversity, federal question, or whatever. And the extra claims that lack original jurisdiction may arise from a common set of facts, that CNOF, common nucleus of operative facts, right? Let's assume that's satisfied and A is good to go, satisfied. When does B take away jurisdiction over supplemental claims or supplemental parties? Well, B is only going to be relevant. It's only going to kick in first when original jurisdiction is premised solely on diversity, okay? Solely diversity. So, for example, my hypo from a little while back where you had plaintiff, a citizen of Florida, say, versus defendant, a citizen of Texas, all right? Change the facts a little bit. To say you have a claim here for copyright infringement, okay? Well, that's a federal question, right? That's going to satisfy 1331 federal question. It's also going to satisfy 1338, which is copyright jurisdiction, all right? Both provide jurisdiction. In fact, let's say the plaintiff is seeking $1 million. Here we go. Makes it even a better hypo. Plaintiff seeking $1 million in damages from the defendant for copyright infringement. Well, we can see here we have 1332 diversity because the parties are completely diverse, Florida and Texas. Amount of controversy is well over 75K. Let's assume that's in good faith and it's possible to get. All right. So we have 1332 diversity. Yep. 1331 federal question. 1338 copyright. Well, if this is all there is in the lawsuit, we don't need supplemental jurisdiction. There's lots of bases here for original. Let's say the plaintiff is adding on, let's say, well, if I have a state claim, I'm just thinking this through. Okay, I'm going to play with this for a little bit. So I'm going to give you your answer in a more roundabout way than I originally intended. Say the plaintiff adds a second claim, all right, for breach of, oh, okay, I know how to do this hypo. Okay, say the defendant does a counterclaim under 13A for compulsory counterclaim for breach of a license agreement and seeking $50,000 damages. All right. All right. We have original jurisdiction here for all those reasons, right? And down here we have Texas versus Florida seeking only $50,000. So let's say the court doesn't allow aggregation here as a counterclaim. Well, we lack 1332 jurisdiction, and we also lack 1331 because it's a state claim, and we lack 1338 because it's a state claim. What about 1367? Okay, A is going to grant. Let's assume the license agreement requires determining whether the agreement gave the defendant rights to the copyright. All right, so A grants. Does 1367B divest? All right. Well, go back to the statute. In the civil action where there's original jurisdiction founded solely on 1332, then you have to ask all those other questions in B to determine whether or not B divests jurisdiction, right? But what's the basis for jurisdiction here, for the original jurisdiction? Is it 1332? Yeah, P versus D is 1332 diversity. But is it solely 1332? No. See that? Because the jurisdiction is not solely 1332, then there's no divestment of jurisdiction at all. So this is going to be okay. B does not divest jurisdiction. Well, let me give you another example. Let me think about this for a second. Okay. Let's have plaintiff, citizen of Florida, versus defendant, again, citizen of Texas. Okay. For federal employment discrimination in violation of federal law, seeking $100 and joins an alternative state employment discrimination claim seeking that same $100 but using a different legal theory. All right. Do we have original jurisdiction over the first federal claim? The answer, yeah. It's not going to be diversity because the amount of controversy is too low, but it is going to be 1331 federal question. 1331. All right. That's okay. But down here, we don't have 1332 because the amount of controversy is too low. We don't have 1331 because it's not a federal question. But 1367A is going to say, hey, both claims arise from the same nucleus of operative facts, and therefore it grants supplemental jurisdiction. Does 1367B divest jurisdiction? We go back here again. All right, in any civil action in which the district courts have original jurisdiction founded solely on 1332, then you go through the other questions and maybe there's a divestment of jurisdiction. Was original jurisdiction founded solely on 1332? And the answer is no. In fact, jurisdiction was founded on 1331. Therefore, A grants jurisdiction and B does not divest jurisdiction. Well, okay, why? Because original jurisdiction was not founded solely on 1332. Now, let me give you an example of where we might have another problem, another thing that you need to look for under 1367B, which is not what is the basis of original jurisdiction, but an additional thing to think about is who is the person asserting the supplemental claim? Is it the plaintiff or is it somebody else? So say you have plaintiff, a citizen of Florida, all right, seeking, let's get some room here, a claim against defendant one, citizen of Texas, for $100,000. Okay, say it is a 3-car wreck. Defendant two is also a citizen of Texas, but here the plaintiff is only seeking $5,000, 5K. How might this happen? Say D1 caused bodily injury to the plaintiff to the tune of $100,000, and D2 merely messed up the plaintiff's car, and the plaintiff is only seeking vehicular damage against the defendant too. Alrighty, do we have jurisdiction? Well, Florida versus Texas D1 is going to satisfy 1332 original jurisdiction, right? And that's going to be the only basis for jurisdiction. Diverse parties, the amount of controversy of $100,000. So that's not a problem. What about plaintiff versus D2? Well, the parties are diverse, but the amount of controversy is too low. And additionally, the plaintiff cannot aggregate the claims he or she has against separate parties. Okay, so there's no aggregation here. So 1332 jurisdiction is lacking. What about 1367? Well, A is going to grant jurisdiction, 3-car wreck. So A would grant. Does B take away? And the answer is going to be yes. It divests, meaning there's no supplemental jurisdiction. And here's why. First, what's the basis for jurisdiction? 1332, right? In fact, it's solely 1332. All right, so since jurisdiction is solely 1332, then you have to continue. And then we ask that second question, right? Would supplemental jurisdiction be inconsistent with 1332? And here, of course, the answer is yeah, because $5,000 is well below the jurisdictional amount. And then we have to ask whether or not the claim falls into one of the laundry lists. Okay, those are contained here. All right, let me clean this up again. Let's look at these laundry lists, and we're going to note something common between all of them. It's first list is claims by plaintiffs against persons joined under 14, 19, 20, or 24. Or claims by persons proposed to be joined as plaintiffs. So claims by plaintiff under Rule 19. Or seeking to intervene as plaintiffs under Rule 24. Now, what's common amongst all three of these scenarios, all these laundry lists? The supplemental claims have to be claims by plaintiffs. Is this a claim by, there we go, here we are. Is this a claim by the plaintiff? And the answer is sure is. Okay, well then we have to ask whether this claim falls into one of these scenarios. So is this a claim by a plaintiff seeking to intervene under Rule 24? The answer is no. Plaintiff's not an intervener. It's the original plaintiff. Is claim by somebody proposed to be joined under Rule 19 as a plaintiff? No, it's the original plaintiff. Nobody's trying to add the plaintiff. Is this a claim by plaintiff against somebody joined under 14, 19, 20, or 24? I want you to think about it for a minute. What rule allowed this plaintiff to join together these two defendants, right? These two right there as co-defendants. Was it 14, 19? Was it 20? Was it 24? Which one, if any, was it? And we'll see, it's Rule 20. This is an example of Rule 20, Rule 20A, I believe Rule 20A2 actually. Rule 20A joinder of multiple, whoops, didn't do that, of multiple defendants. Now, because this is joinder of, this is a supplemental jurisdiction over a claim by a plaintiff against a person joined under Rule 20, okay, there's no supplemental jurisdiction at all. B divests it. So we've learned a couple things. The first thing you want to ask under B, I mean, if you want to, look for crucial facts is, what's the basis for original jurisdiction? If it's only 1332, then you may have a 1367B problem. Second, who's asserting the supplemental claim? Is it a plaintiff or is it somebody else? If it's a plaintiff, then again, you may have a 1367B divestment problem. On the other hand, what if the supplemental claim is being asserted by someone else? In that case, B won't take away jurisdiction. So say, for instance, you have a case like this. So this will be a third scenario. All right. So suppose you have Florida plaintiff, Texas defendant, and a Texas defendant in pleads under Rule 14, co-tortfeasor, right? Our classic 3-car wreck. All right. We have P versus D for $100,000 for negligence. All right. The Texas versus Texas is by way of impleader under Rule 14, seeking $100,000. In other words, this guy, the third party plaintiff, is saying to this other guy, the third party defendant, that, hey, TPD, if I, the TPP, owe any money to the original plaintiff, then you, TPD, are going to owe all or part of that to me. That's how our Rule 14 impleader works, third party practice. All right. Now, what's the basis for original jurisdiction here? You got it, 1332. Would 1367 grant jurisdiction under A, supplemental jurisdiction? The answer is yeah, sure it will. Why? Because 3-car wreck, common nucleus of operative facts. So we're good. Does 1367B take it away? And the answer is no divestment. No divestment. In other words, we're okay under 1367B. And the reason is that even though jurisdiction was originally okay under 1332, this is not a claim by a plaintiff against a third, against somebody joined under Rule 14. This is a claim, let me get my highlighter, by a third-party plaintiff against a third-party defendant. And to be clear, the statute has not been read to treat this person as a plaintiff. This person is a third-party plaintiff. The only person who's a plaintiff here is this person. Put differently, 1367B does not bar supplemental jurisdiction over the claim of this third-party plaintiff against this third-party defendant, even though they're both parties of both citizens of the same state. And again, in summary, going back to 1367B, what are two of the things we're looking for is, what's the original basis for jurisdiction? Is it solely 1332? If so, Houston, we may have a problem. And who's asserting the claim, the supplemental claim? Is it a defendant? And not a problem. Is it a third-party plaintiff? Not a problem. But if the person asserting that claim is a plaintiff, then we may have a problem and we have to do the full analysis. All right, so I'm going to go back to the main screen. I'm going to turn off the screen share. Jeremy, please let me know if that was helpful to you. And just send me a quick, excuse me. There we go. Send just a quick comment via the Q&A to let me know if that helped you out. All right, now I'm going to go to Kamar's question. Erie. Yeah, you're not the only person that has problems with Erie, Kamar. The Supreme Court does as well. They've made quite a mess of Erie doctrine. Now, I'm going to handle this in two ways. Oh, you're very welcome, Jeremy. Thank you. All right. Oops. Let's go back to. There we go. Here's a question we'll answer. And while I'm responding to Kamar's question, I'll just remind the viewers that if you have any questions, that you'd like to pose, click on the grid icon up in the upper wherever it's pointing. I guess that's your right hand that way. And click on the grid, and then click on Q&A, and then you can pose any questions you might have. All right, Erie. I think the main things you're probably going to have to know about Erie for the bar exam are really pretty basic. Okay, and here's why. Erie's a mess. A lot of the questions in Erie involve very difficult questions that are in gray areas of the law that probably make for very poor bar exam questions in terms of the MBE. A lot of professors like testing on Erie. They're 1L exams, but I'm not sure how easily testable Erie is. At least the difficult questions in Erie. I'm not so sure how testable those are in the context of a multiple choice question in the bar exam. What I think you absolutely do need to know is the following, and forgive me, I'm talking off the top of my head, but the first thing you need to know is in cases that are not resolved by federal law, right, or it's not a federal question or a congressional statute or some sort of common law that's created under federal law, right, like a Bivens claim, where the rule of decision is one of state law, okay, then state law governs. And what I mean by this is when a substantive law, say like a negligence claim, as in the Erie case, or say it's a contract claim, where somebody is not actually raising federal law, and they're just asserting your normal old common law claim, then the federal court must use the relevant state's law in resolving it. Okay. Now, it's always been settled that if the relevant state law is state statutory law, the Supreme Court has always applied that, even before the Swift versus Tyson case. What was goofy about Swift versus Tyson is there we go. Okay. Under Swift versus Tyson, what the Supreme Court said is that in cases involving a common law, the federal court wasn't bound by the state court, right? That it could come up with the law itself, come up with a better law. But that was overruled in the Erie case, and the Erie case court held that it was unconstitutional to ignore otherwise applicable state common law, and for the federal court to come up with its own common law, right? What courts refer to as the general federal common law. That's now unconstitutional. So one thing for you to watch out for in the bar exam is a question where the federal court ignores applicable state common law and wants to come up with a better law. But that's unconstitutional. You can't do that. That's one thing you absolutely, in my opinion, absolutely have to know. Another thing to keep in mind is, of course, which state's common law would apply. All right. So that's the intersection of choice of law and the Erie standard. Okay. What Erie tells us is we use common law. We use the law is not articulated by the highest court of the relevant state. All right. Now, oftentimes the highest court will have spoken on that issue, right? Say, for example, the Florida Supreme Court has spoken on whether or not contributory negligence is a valid defense, or has the Florida Supreme Court in terms of comparative negligence. I'm just making this up as a hypo. You've studied this stuff, you likely know what Florida does. Okay, if the Florida Supreme Court has spoken on this issue, then that usually determines what the relevant state common law is. But a federal court sitting in diversity isn't required to always abide by what the state court has decided. First, what if the Florida Supreme Court never decided the issue, right? Then the federal court has to predict what the Florida court would do. Second, what if the precedent as articulated by a state highest court, say it's really old, or for some reason it's questionable, Well, what the federal court's supposed to do is predict how the highest state court would resolve the issue if the issue was presented to that court today. It's called making an Erie prediction. So, in addition to remembering that federal courts can't just make up common law actions, we have to look to the laws articulated by the highest relevant state, which it usually may involve making a prediction. Okay. And of course, there's always the issue of choice of law. We're not talking vertical between state and federal, but horizontal state to state. Which state? All right. I kind of doubt that you're going to be tested on choice of law principles, those horizontal choice of law principles, because each state has different choice of law laws. Some look to the law of where the accident was, some look to interest analysis, right? So I doubt that that's going to come up on the MBE. But keep in mind that a federal court sitting in diversity, when it's applying common law, not only has to predict and apply the law of the highest state court, but has to figure out which state court would apply, right? So, what if you have a contract between somebody from Florida and somebody from Wisconsin, and different parts, the payments in one state and execution in another state, payment in one state, maybe performance in one state, other performance in another state. Well, which state's law is going to apply, right? Wisconsin or Florida? Well, then you're going to have to know the choice of law principles used by Florida and Wisconsin, which is, I doubt that the MBE is going to expect you to know that. That just doesn't seem likely to happen to me. All right. So again, sum up those first 2 points. Number one, federal courts don't get to make up state common law. We use the state common law. Second, use the common law as articulated by the relevant state's highest court, or make that prediction when law is not settled or unpredictable. Third, give me a second. Third is, what about when the relevant dispute is between federal law and state law, but it doesn't involve substantive state common law, like the standards for a contract or the duty of care in a negligence case, right? Well, then it gets a whole heck of a lot more complex, and I suspect that the MBE can only ask the most very basic questions in this area before it gets just unreasonably testable, unreasonably untestable. Would that be just untestable, right? So let's keep it to the basics here. And then after I sum up, I'm going to refer you to some materials on my website that might help you. All right. Well, if the conflict is between judge-made procedural law, okay, and state law, so like state procedural law, then we have to engage in modified outcome determination analysis. In other words, the analysis contained within the first part of HANA 1. All right. So imagine that we have a state law would use a statute of limitations with a fixed date. And say federal law had a preference for using a more equitable considerations like latches. Well, in that case, the federal court would ask that inquiry under HANA versus Pullman, right? Would selecting federal law over state law lead to forum shopping? Would it lead to inequitable outcomes? Okay. Well, you can see already that that's kind of going to be hard for the bar exam to ask, because in an interesting enough case, it's going to be very debatable which way to resolve that, right? Makes it, I think, a little problematic in terms of how would you test on that in the bar exam. But what we're talking about here is HANA Part 1. And this is when you have state law versus judge-made procedural law, federal judge-made procedural law. All right, use HANA Part 1. What if the conflict is between state law and a rule of the FRCP, right? Like Rule 4, right? Well, in that case, it's almost certain that the FRCP is going to be state law, And here's why. Hannah Part 2 tells us that when the dispute is between an FRCP and state law, we don't use outcome determination analysis. We don't use modified outcome determination analysis. Instead, we analyze the dispute between an FRCP and state law by using analysis under the rules of decision. Excuse me, the Rules Enabling Act. The Rules Enabling Act. That's 28 U.S.C. 2072. And that's very deferential towards federal law. So long as the federal procedural rule, the FRCP rule, really regulates procedure, then it's almost certain that the FRCP rule is going to be applied over the state competing, conflicting state law. Okay. The Supreme Court has never held an FRCP rule to be invalid under the Rules Enabling Act. In theory, it could, because even if a FRCP rule really regulates procedure, it'll still be held invalid if it, under the statute, modifies, enlarges, or abridges any substantive rights. The Supreme Court has yet to find an example of where that's occurred. Now, you can see, I've only scratched the surface with Erie, and it's already kind of horrifically complex, which kind of explains why I think some of these things are unlikely to be tested. So let me again summarize very briefly, I think, the three or four key points you need to know. If the dispute is between state common law and a federal judge making up federal general common law, right? Well, federal judge can't do that. We got to use the state common law. Second, that state common law has got to be that coming from the highest relevant state court, which may involve making an Erie prediction, right? What would the state highest court hold if it was presented with this issue today? Third, if the dispute is not involving substantive law, but rather procedural law, well, then we ask, what if it's judge-made federal procedural law, like latches, a preference for latches versus state law, such as a state statute of limitations. In cases like that, the federal court's going to be concerned with the dangers of forum shopping by plaintiffs and inequitable outcomes, right? All right. And then finally, what if the dispute is between the federal rule of civil procedure and state law? And in cases like that, it's going to be usually the FRCP rule is going to be used. Put differently, if the dispute is between substantive law and substantive state law and federal law, usually that means it's going to be used to state law, right? Duty owed a trespasser. And if the dispute is between an FRCP and state law, the FRCP is usually going to be used. And if you take all that simple thought all the way back to the first day of law school, you'll see that this is something you kind of know from the first day of law school, right? When you take FRCP class with me or any of the other profs, you see very quickly that in federal court, you use the FRCP, federal rules, right? But if it's a common law claim, we use the state common law to determine the rights of the parties, right? The substantive rights. Now, I said I was going to show you a resource, so give me a second. I'm going to pull up my website, and I'm going to show that to you. Oops. There you go. Screen share. All right. So we're at the Nathenson website. Click on teaching, bar exam resources. It'll take us there in a second. Let's go down to the Erie section. Here we go. Tap on that. And one of the things that I added last year that you guys didn't have the benefit of, because I just created it last year, is a flow chart on Erie. I also have problem sets. You can look at all that stuff and all these handouts, right? In fact, the website's filled with handouts. If you tap on the Coggle flow chart, it's humongous, all right? You can either go through the Google site or just download a PDF. Let's go to the PDF. And this is Erie. Pretty complex, isn't it? It's as complex as personal jurisdiction. My former students amongst this group can remember that I do PJ Big Picture Day, and I have a big flow chart that I developed for that. All right. You can see how complex this is, but if you want to review Erie, I might suggest you go to this Coggle and go through the various steps, right? Step 1, determine content of state law. Step 2, determine content of federal law. Step 3, determine the type of federal law conflicts with state law. And then step 4, analyze the conflict. And that's kind of what I did with you guys today. Obviously, it'd be pretty impossible for me to go through this whole thing with you today in the context of an online review. This is probably like a whole 2-hour session right there. But I think if you spend some time working through this flow chart, that might help you a little bit. I think it will also show you how, not all of these things, but a lot of the determinations here are so indeterminate that it makes it difficult for some of these matters to be tested on the bar exam. So what I've done is tried to focus in our talk today on things that I think might be testable on the bar exam. Okay, let's see. Marianne, you're very, very thankful. Okay, so you're very welcome. That's great. Thank you. And all right. Well, let me give you guys this last opportunity to ask any questions you might have. I think my voice is starting to go. This weather's getting to me. If you have any questions, click on the grid icon, click on Q&A, pose the question. I'm going to give you guys a few minutes to see if you have any other questions. And if not, I'll let you go and wish you all the best on the bar exam. Kamar, you're very welcome. All right, well, you guys have been great. I'm going to take that as you're good to go. Best of luck to you on the bar exam. Thanks for spending some time with me today. And I'm looking forward to seeing you all as colleagues in the practicing bar real soon now. All right, so best of luck to you all. Have a good day. Be well. Stay healthy and rested, and good luck on the bar exam. Bye-bye now.